Go 5 minutes.
Full.
Next week, my lord.
We are in that issue of Cedar. What is
Creation.
Cedarship?
Creation of
My colleague was stuck there.
reviving of the lost statehood they call. Domains of
After a
say.
week.
Okay.
Just after a week, the request made on the petition. Yes. Yes.
Legally,
Item
I have
8.
item 8 of the hearing. My lord, I have taken the consent of Dr. Nitish
Yes.
Mujaika. Let it come on 12th. I have got another matter before your lordship on 12th. I want to do it physically before your lordship.
No, we will not give you a fixed date. We are not giving fixed date. So if we accommodate, then we have to give fixed date to everyone.
Let it come after 2 weeks, my lord.
It will come after
2 weeks, my lord.
after 2 weeks.
Deeply obliged, your lordship.
Yes.
Deeply obliged.
Lordship,
On the request to petition. Yes.
Lordship, I beg to mention item number 11. The conducting council is on sanction leave, Your Lordship.
Yes. What is the matter about this?
This is the CBI, my lord. Grant of pardon to the co-accused. I heard several times.
It was hard also. This.
I heard several times, my lord. Earlier, Delhi Council also argued the matter, my lord. Mr. Pandit also argued the matter.
That is approver. That.
Approval, my lord.
So again, time has been short today also. See, there are many matters, you see, like we unnecessarily spend time, but then anyway. So we'll adjourn it after 2 weeks.
But it is a sanction leave, it seems.
11 also after 2 weeks on the request of the petition. 2 weeks.
Obliged, Lordship. Your Lordship, I beg to mention item number 15, Your Lordship. The conducting council, it's fixed for hearing, Your Lordship. The conducting council is indisposed. We have already spoken to the other opposite council.
You are
Your
making a
Lordship.
mention on
They
behalf of
have
the
no
petitioner.
objection.
You
Yes,
are
Your
making a
Lordship.
mention on behalf of the petitioner.
Yes, Your Lordship.
You are also there.
I am respondent number 3, Your Lord. It's a petition under 482 for
So
question.
when do you want it?
After 3 weeks, Your Lordship.
No objection, Lordship.
A relatively new matter. My lord.
Yes. This 15 also after 3 weeks on the request made on behalf of the petitioner. Yes.
Obliged.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 13.
Item number?
13, Your Lordship. Lordship, I'm appearing for every respondent number 7.
Who is petitioner? Yes.
Lordship, I pray for 2 weeks' time, Your Lordship, due to personal difficulty of Mr. Paul Pasque.
Lordship, can it be just 1 week because the matter is coming up on the 6th? So can it only be 1 week, Lordship?
1 week, Lordship.
1 week.
Yes, Lordship.
13. 1 week on the request made by the parties. After a week, huh? List after a week. The request made.
Bless you, Lordship.
Yes.
Any causes? Item number 1.
Lordship.
May it please, Your Lordship. Lordship, I seek indulgence of Your Lordship to kindly consider the matter on Friday, Your Lordship, in view of the fact that the conducting council for respondent number 5 is in bereavement, Your Lordship. Just this Friday, Your Lordship.
Mr. Paul.
My lords, my learned friend did tell me there was some urgency in the matter, but my learned friend is making
bereavement, that is the main thing.
It's I will not press it.
We understand that.
May I just pray, my lords?
Yes.
If my learned friend can accept notice and your lordships can fix the matter on Monday for the purposes of hearing on the interim, my lords.
That will be all right. In the meanwhile, you can have instructions.
Because the instructions can be completed by then, my lords. The matter will be arrived.
Then we'll issue notice.
My lords.
Okay, and then we'll just say for interim.
We've already served copies, my lords. It's just the formality of issuing notice. So your lordships may fix the matter on Monday next for hearing on the interim.
Okay. Heard Mr. Kapal on a counsel for the petitioner. Issue notice. Returnable in,
3rd of June, my lords, whether that would be convenient.
that is the main matter.
My lords.
Oh, achha, that there is no separate miss case.
There's no separate miss case, my lords, in the main matter itself.
Issue notice. Returnable, why? It is next Monday is
3rd, my lords.
3rd of May. Okay. Then you have to write the name of the thing. Mr. Who is for the state? So and so appears for person number 1. Then
2, 3, 4. I think would be
2,
my
3, 4.
my learned senior Mr. Kinta will be appearing for 2, 3, 4 minutes.
Mr. VGK Kinta, Fairness Council, appearing with Mr. Kinta. You are appearing with whom? You are appearing alone. There is no one there with you. Can you accept notice? He will be there. Okay, Mr. VGK Kinta, along with so and so appears for the respondent number 2, 2, 2, 3, and 4. Then
I'll create for respondent.
Mr. So and so for 5. And then Mr. 6.
6 and 7, my lords, I think.
And as such, no formal notice is called for. The respondents shall obtain necessary instruction in the matter. At least this matter.
Lord, had it be
Oh,
Tuesday.
already. You before one thing, just use a rule returnable after returnable within a week, without giving a date. And down below, just say list this matter on such and such day for consideration of interim period.
Monday next.
Lordship, let it come out on Tuesday, Lordship. Monday, there's slight difficulty on behalf of the conduct. Tuesday, Lordship.
Tuesday.
One day difference.
Okay, then
4th.
change it.
Yeah.
Tuesday is all right for everyone.
4th, my lords.
4th.
Oblige, Lordship.
Item number 2.
Lordship, I'm appearing for the petitioner on behalf of Ms. P. Agarwal in this matter.
Yes.
Lordship, if the matter could kindly be taken up after a week.
Have you filed a rejoinder?
The petitioner is directed to file a rejoinder, my lord.
Have you filed a rejoinder?
Still in orders.
No, Your Lordship, we are about to file.
You are about to file.
Yes, Your Lordship.
You want time, further time for that?
Yes, Your Lordship. A week's time may be permitted.
That will be enough for you. A week's time.
Yes, Your Lordship. Yes, Your Lordship.
Okay. The petitioner prays for grant of further 1 week's time for filing a rejoinder against the appearance opposition
Of 2, my lord.
respondent number 2. Dear Lord, list after a week.
Much obliged, Your Lordship.
Item number 3.
This is for instructions.
Yes.
Lordship, the senior counsel is on like with other court if this matter may come up after.
Who is senior counsel?
K. Khan.
You are also very senior, Mr. Abraham. You can have instruction. Yes, Mr. Khan is here.
Sorry. Apology, Your Lordship. What is happening?
What is this matter about?
So this is the coal matter, my lord. MMDR Act. The coal was seized and the case was registered.
Oh, you say you have legally procured.
Yes.
This was procured by auction, buried auction, and they have seized it.
Yes.
Yes, Mr. Khan, have you taken any instruction?
Lordship, we have,
If his contention is correct, then
Lordship, we have asked for instruction. We'll request some more time, Your Lordship, please.
if it is correct, what he
Lordship,
contends.
Lordship is correct. If what he contends, then he has a case.
If it is not that, those stuff which he procured in an auction, then it's a different issue. But then
Lordship
you
is
have to take a stand. You have to take a stand.
That stand is important. That is true.
Because on last occasion, interim trial was refused only because this concerns factual.
On that part, Lordship,
482, you say, like, it's quite difficult.
Lordship, kindly just give us some time. We'll definitely come back.
How long will it take? How much more time you will be needing?
Lordship, kindly, please 2 weeks. We'll definitely go with instruction.
Okay. See. On the request made by Mr. K. Khan Ranade, addition AG. Just say Mr. K. Khan Ranade AG. Praise for grant of further 2 weeks' time for obtaining instruction. Trial allowed. List of please.
Obliged.
Hearing item number 5.
Yes. Yes. What was the matter about? This is, you see, like, it's a problem. You see, like, if there is a gap, considerable gap between the hearing and this court forgets everything.
Well, this is that matter where there were those 2 schools. Your lordships had heard
By the same
matter.
name.
My lords. And my lords, the state was directed to seek certain instructions and place it before your lordships.
That is specifically with the managing committee, probably. Like it was
where
shown.
the money was going prior to the creation of the new school, my lords, or shifting of the school.
Because, what was detected by this court is that even after the day on which the respondent alleged the petitioner has left the school,
my lords,
she found to be a member of the managing committee,
my lords,
and that managing committee basically ran for some
another
more
2
period of
years, my
time.
lords.
So that the question was that, like, how can a person who is a part of managing committee be outside school? So that is what is to be
2 aspects, my lords, where the money was going and what
Yes,
steps were
yes.
taken by the state, if at all, to remove the petitioner.
Yes, then
Your Lordship, if this matter may be taken up at the end of the court, Your Lordship.
so alright, but then we have a division bench also. So
Well,
that is the main thing. So it's up to you. All right, end of the board.
Oh, may I pray, my lords, if your lordships are not inconvenienced, if we could have it after a week. Else I'll have a little difficulty in the second half.
That is perhaps we also do not know. The thing is that like how long division bench takes, that is what we do.
My
not
lords.
know. It may be 2 minutes also, it may be 2 hours.
My lords, my lords.
So that is what. So
Next
it's up
week,
to
my
you.
lords.
If you agree upon it, then
My
it's
lords,
all
if your lordships kindly.
just on the joint request of the parties, release this matter after a week.
Item number 9.
Yes, Mr. Gohan, what is the matter about?
My lord, this is a matter, my lord, where the petitioner was allegedly arrested on the ground that his visa was forged. This.
Oh, sure, yes, okay.
Yes, my lord.
It was hard long that.
My lord,
There's a time
I
after time.
respectfully submit, my lord, that this is a case, my lord, just before going into the evidence, my lord. The day I was arrested, my lord, on the suspect that my visa was forged, my lord. At that point of time, my lord, my visa had not expired, my lord. It had not expired. That is in the record as well as in the order also, my lord. Now thereafter, my lord, that forgery and using the forced visa is genuine, my lord. My lord, here
the day on which you were caught, which was the date on which it was caught?
I was caught,
Your
my lord.
visa was valid up to 17/10/2011.
My lord.
Visa was valid up to 17/10/2011.
My lord.
And the alleged fake extension was up to 16/10/2012.
My lord, I have been acquitted from those.
So far as the fake things concerned. Now
Exactly.
far is that your stay.
Stay, my lord. At that point of time,
Now-
when I was arrested,
See,
my lord.
Yes. When you were, on which date you were arrested?
My lord.
Prior to 17/10 or?
Yeah, prior to, my lord.
17/10/2011.
No, it is 2012, my lord.
This matter was almost completed. No, this for what reason that has been?
It was, my lord, pending for placing some judgments, my lord. And in spite of all my endeavor, my lord, I could not find any similar kind of judgments, my lord. Now,
Yet the prosecution was supposed to supply you a copy of the.
I have supplied,
visa-
Lord, copy
this
of
thing.
the
There is something with regard to that.
copy of the exhibits, Lordship. I have supplied, and my learned friend was taking time to compare it with the original, Lordship.
my lord,
Where you got stuck? What is the issue there? There is something in relation to this. And we do not know this. The notes which are made by this court also.
my lord, at page number 2 of my paper book, my lord, that is the FIR. It will be clear from there, if I may read, my lord. Page number 2.
Here, page number 2
2, my lord.
of your paper book.
My lord, yes.
Paper book is, it should be 1 page number, the first. 2 is charge.
Yes, copy of FIR is there, my lord, at page 2.
Page 2 is the continuation of page 1. Page 1 is the FIR. 19th June 2012.
My lord, if I may read, my lord.
Just a minute. Your visa expired on 17/10/2011. So after that.
No, my lord. My visa is valid till 4/2/2014.
No. There's something wrong.
Hold a passport valid till so and so, and registration current.
Paper book is page 2 FIR. Your paper book, FIR is page 1. It's corrected one. This is the first copy. This is the first copy.
The page 1.
Yeah, I've got this corrected copy.
Yes.
That is the case. See, probably we got stuck in a point where you were exonerated from the charge of, committing any forgery.
My lord.
But then your stay, whether it is legal or not, because admittedly your extension was done with retrospect to your effect. Now that is what you see, like the losses cannot be done.
The issue which remains here, Lordship, is the date of the second extension. When the second extension was done. If it was done in time, Lordship, that means
Valid.
it's all right. It's valid. If it was not on time, then he'll be
that is
liable under Section 14 for overstaying.
that is
Let my colleague point out.
even if you
That's the
assume
issue.
that it was done correctly, but then it was done at a later stage. So that is what the issue to be addressed upon.
My lord, as of my understanding, my lord, before the learned trial court below, my lord, the issue were whether the visa were forged or whether I have stayed beyond my extension, my lord, after the expiry of my visa, my lord. So forgery has been disproved, my lord. Now, admittedly, at the time of my lord, even if we take a pause at this moment and assume that it was forged, my lord, extension, my lord. Now, once I have been, my lord, I was being discharged from forgery, my lord, and using the forged visa as genuine.
Let us not assume it is not. Let us say it is correct. It was not forged.
My lord.
Then even also extension.
My lord, I have got a.
How can it be this? See, this extension will not cover your stay.
Whether that was an issue, my lord, before the trial court below. Under 14, whether I am.
For determination, see, something is automatic. Say, supposing if you have to determine that whether your stay was legal or not, then this issue comes. That is what is to be decided.
Yes, my lord.
Otherwise, that how it will be. See, here only thing here the case proceeded on two things. One is there was allegation of forgery. Second was that there is illegal stay.
My lord.
Now, so far as the forgery is concerned, you are exonerated. Court did not find any material to these things. Now, second issue came, your stay, the legality of your stay. Now, while determining that question, it came to light. Now this court remembers. Probably we called for that thing and we perused it. And there we could find that this extension was made later. So your stay, whether this could have been legalized. See, even if law says it can be legalized, then you are not liable. But then it cannot be legalized, then you are liable. That is what.
My lord has given me that option, but before I go to the second option, what my lord, what has fallen from my.
No, there is no option. You see, that is basically what we say. We will not give you any option.
My lord.
That is what the understanding of law is. Now, if you say it is not correct, then you show us the law.
My lord. Now, my lord, my case is that, my lord, at that time, extension of my visa was not done subsequent to my arrest, my lord. It was prior to my arrest, my lord. It was not subsequent to my arrest, my lord. Prior to my arrest, in the month of June, when allegedly that first visa extension was till the month of October, my lord.
There is no question of arresting you.
Yes, my lord.
Prior to extension, because there is it is only came to light after verification of sort in this regard.
My lord, if I may clarify, my lord.
If you see the FIR, just let us see the FIR. Please read it.
If I may read, my lord.
Yes.
Page 1.
Yes.
With reference to the subject cited above, I am to inform you that Mr. Godfrey Albert Decker, a Nigerian national holder of passport number so and so, dated 5/2/2009, valid till 4/2/2014, that is the passport,
yes,
bearing visa number so and so, dated 18/10/2010, is a registry of this office by registration number so and so, dated 6/9/2011, currently playing from Malki Football Shillong. The said Nigerian has obtained visa extension in 2 occasions from the Office of Foreigners Regional Registration Officer FRRO, New Delhi, duly signed by the Assistant Foreigners Regional Registration Officer, New Delhi, number so and so, dated 15/10/2010, and so and so, dated 15/10/2012. On scrutiny of the visa endorsement of the current extension, it is found that there are some contradictory in the said endorsement, like the date of validity of visa and memo number so and so on the visa endorsement. In view of the above confusion, this office has sought a clarification from the office of the FRRO, New Delhi, about the visa endorsement on 18/6/2012, received from the FRRO, New Delhi, number so and so dated 15/6/2012 has confirmed that Mr. Godfrey Albert Decker has never registered with his office and no such extension of visa was granted by his office. Moreover, the stamp which is affixed on the visa was also fact. In this connection, you are requested to initiate appropriate legal action against the said person as per law. Now, subsequent to which, my lord, the case was registered, my lord, as SADAR PS case number 1026/2012 under section 468,
Evidence.
471.
Give one evidence. Yes, please.
Yeah. Subsequently, my lord, a case was registered under section 468, 471, read with section 14 of the Foreigners Act, 1946.
Where is that exhibit, that material exhibit? Mr. Kharmi, you had produced on the last occasion probably.
Yes, I have produced
Has
it.
it been returned to you or?
No, it's in the custody of your court, of this court.
Just. That is the deposition. No, where is that exhibit? Not deposition. The passport, the visa.
It's before your lordship.
Is it?
Passport and visa.
Is it not that you have taken it for giving him a copy?
No, I've already xeroxed the copy.
So the original was submitted here?
Yes, lordship. I have submitted.
There should be one envelope, the passport and the visa, not this deposition. Yes, this should be. This code is refreshing. You see, like that was what was seen and what was not seen. No, that was the issue, isn't it? He was permitted to stay till 16/10.
Yes.
And this order was issued only on 15/10.
Yes.
His earlier expiry was up to 17/10.
17/10.
So it means it should have been
2011.
from 18/10/2011. Now that was the issue.
Date of issue 18/10/2010.
Yes.
Permitted to stay up to 17/10/2011. First extension.
Because Mr. Gurung's contention was that once he is acquitted of the charges of forgery, he could not have been, you see, made answerable for his stay in this thing, because it's not at all this thing.
Yes.
Now, assuming that there was no forgery in extension, going by the admitted fact or whatever is shown, then also his stay becomes illegal.
Yes.
Yes, Mr.
My lord, I was arrested in the month of June 2012. My second extension was on 15/10/2012. 15/10/2012, I had sought my this thing, my lord, extension.
See, your previous extension, the was till 17/10/2011. Okay, and thereafter you stayed here. And so far as the endorsement on the passport is concerned, it says that your stay was extended till
16/10/2012.
2012, but then the order was passed on 15/10/2012.
Yes.
15/10/2012. Just one day before the expiry.
So that is what the question was that that till this order was issued,
Yes.
you were staying here there illegally.
Yes.
Because there is a lapse of almost 1 year time from the expiry of your previous
Visa.
previous visa till it is renewed. Now, whether you see by a retrospective extension, this period could have been legalized or not. That is the issue.
Exactly.
Otherwise, all those facts are not denied. Okay, now forgery may relate to that who made those entry into the passport, who manufactured a seal to put it there and all. Now it seems you have been exonerated, but then the one fact remains that this is your passport. There is unravelable your passport. Now there may be certain provisions in the Evidence Act where an accused also required to explain certain situations appearing existing. There you cannot just say that this burden also is with the prosecution.
My lord, I am not saying that, my lord. In my when my statement was recorded, my lord, I had categorically submitted that I was injured during football, and there was a person called Sebastian who was in the business of, my lord, helping the person like accused for extension of visa on charging of certain fee, my lord. So on that belief, my lord, because his friends had been doing other footballers, here categorically submitted that he had handed over money and the passport for extension of the visa, my lord. In that case, the learned trial court has made an observation that this Sebastian was never, my lord, examined, my lord. IO thought that he was not required. That is the statement of the IO also, my lord. More so, my lord, where, my lord, the seal and the extension of visa, which was, my lord, as per the prosecution, my lord, is said to be forged, my lord. The said authority from Delhi, my lord, nor the seal was compared, nor his statement was recorded, merely on the basis of, my lord, this fax message, my lord, which is not admissible under the law, my lord. So taking into that consideration, my lord, because I have categorically stated.
What about the entry in the passport or the visa that has been exhibited before the court?
My lord, yes, subsequently.
No, whatever it is, but then it is
because my lord will appreciate, my lord, as a dutiful, my lord, law-abiding person, my lord. The moment I reached Shillong, my lord, I had reported before the FRO in Shillong, my lord, my arrival. I had myself. It is not that a case that I was arrested from hotel or something, my lord. I had reported with my passport and visa, my lord. That is the case, my lord.
Now the problem is that, Mr. Rose, we can understand maybe there is a bona fide on your parts, but the thing is that if you engage somebody who is a fraud, and then thereafter consequences come to you, which way you safeguard yourself from that? Is it not my fault? Say supposing, of course, this is an assumption. We are not saying anything. We are just saying that, like in a situation, you in good faith engage somebody for doing certain purpose for your work.
Right.
Now that person whom you engage, he is a tout. He is a fraud.
My lord.
And he commits forgery in doing your work. It is not detected then and there. You accept it in good faith.
My lord.
And subsequent, before the, the appropriate authority, you are caught. Can you take a defense that it is I have not done? I was in good faith. See, I have done this, I have done this. Will it exonerate you from the criminal liability?
My lord, as per my understanding, my lord, even the law says that, my lord, in order to prove forgery, my lord, the maker of the forged document has to be examined, my lord.
that is we are not on forged. We are on admitted thing. We are not saying that has been forged. We assume it to be correct. But even then also, your extension comes after the expiry of the period. So can it legalize? Can it legalize the stay, which was
Probably-
admittedly without any extension?
Probably, my lord, is
That is the question to be reported.
pointing at, my lord, ignorance of law is no excuse, my lord. Something like that.
No, you see, ignorance is no excuse. It is a known thing. There is no question of that. We are not saying that. You see, kindly try to see. There may be something like this. The communication which court is trying to make to you, maybe the court is not able to do it properly. The thing is that we assume that the entry made in the passport is correct. There is no forgery. Okay, the allegation that there was a fake seal and all those things, we assume that that is all these are correct. We just say, okay. Even then also, the admitted position would be that your stay stood legalized only at the end of the period. Would be done. Probably that day, other day, we came across some law that there cannot be retrospective extension.
Yes, yes.
Okay, so before you resume your stay here, you must have a valid visa. It cannot be something like that. You complete your period of stay and then you obtain visa. So that is the difference.
My lord,
So how do you escape from that situation? That is the question.
throughout, my lord, my visa, along with the passport, was in the custody of the investigating authority, my lord.
That is after your arrest.
My lord, I was arrested in the month of June 2012, my lord.
Say, Gurung, you have to give us something acceptable. If you want to explain it, that's no, we are not saying.
I got the
We
query.
are not saying that these also will conclusively prove that the offense against you.
My lord,
Even
I-
that also, there may be a route of escape. But then, how do you answer that question? That remains with you. And you will just come back because we will have to go and sit in.
My
the-
lord, my lord.
Yes.
My lord, before my
Do not
friend-
get discouraged by the query of the court.
No, my lord.
This court
My
also
lord,
has the
in-
intention, please.
My lord.
This court also has the intention to get enlightened on that point.
My
that
lord,
part.
my lord, I'm deeply thankful because
I do not know whether court is able to convey you to that point or not.
my lord, I got it just now, my lord.
Yes.
I'm very thankful I'm being enlightened on the very query of this honorable court. It was not sinking my head, my lord. Now I have come to the exact query of this honorable court, meaning thereby, my lord, since my second extension was on 15/10/2012 and valid till 16. So my first extension, between my first extension and the second extension, that is between 15/10/2016, my stay whether
See,
yes.
your earlier, your
Yes.
first validity was till 17/10/2011.
Yes.
So from 18/10 till 16/10/2012.
Yes, my lord.
That was legalized later.
My lord.
So that is what the query.
My lord.
Whether that could have been done.
Yes, yes. I got the query very exactly, my lord. So even in the statement of the my lord, the complainant is there that his visa, the first visa, got expired in the year 2010, but in the month of July 2011, he had left Shillong, and we thought it was for extending his visa. But later on, we came to know that he was still in Shillong, and he was summoned again. Why you were staying in Shillong after the expiry of the visa? Then he informed the complainant that it has already been extended. So my lord's query is that whether that can be legalized by subsequent. My lord, to that, now I got the exact query, my lord. I may be given 2 days time, my lord.
Definitely, you can get it. If you get it, that will help the court
Yes,
also. Otherwise, also court will have to think
My
something
lord,
about
my
that.
lord, my
You see, but then doesn't take it to a. You see, do not take it that way that the court has already
No,
taken
no,
a view against it.
no, my lord.
You
Never.
see, definitely, other things will be considered.
Never,
But then
my
that
lord.
was a good point.
Never, my lord.
So even court also has the desire to know.
My lord.
Issue is only thing is
I'll
that
try to give the best assistance.
whether your illegal stay can be legalized subsequent by subsequent grant of visa. That is. Yes, Mr. Kharmi.
Yes, Lordship. Or whether it has got a
Yes, let him find out
retrospective effect
if
or not.
something.
1510. Yes.
That will
My
enlighten
lord is
us also.
Yes,
absolutely
yes.
correct.
Yes, Lordship.
When 1 week will do.
1 week, my lord.
Just on the request of the petitioner, this is matter of. Just you say, Mr. Gurum, Granite Council for the petitioner submits that we need some time to enlighten the court on the question as to whether stay of a foreign resident can be legalized by subsequent extension of visa. Can be extended by visa granted subsequent. Or same thing, is it same thing? Is it subsequent grant of visa? Stop. They'll run it. What is it? Just say, Mr. R. Guru. Just say what is the start of the thing? Stay of a foreigner, foreign national. Stay of a foreign national legalized by subsequent grant of visa. Subsequent grant of visa. Just say prayer alert list after a week.
My lord, even off the record, my lord, off the record. My lord, as per the act also, my lord, that since my passport and visa was in the custody of the, on my first report, in the FRO Shillong, the FRO Shillong had knowledge that my visa had expired, which is why I was summoned, my lord. As per the act, my lord, so far I know, my lord, that the duty of the FRO is to serve me a notice to leave the country. Well, I'll satisfy my lord in that.
Definitely, so far as the criminality
Man,
of this
man.
thing is concerned. That is all right, Mr. That is why you see, Mr. Gurung, right from the beginning, court has said that do not take it that way. That court has already taken an adverse view against you.
My
It
lord,
is not that. We are
my-
yet to hear the matter.
My apology, my lord.
But
It
then
did not
since
sink my head, my lord.
Since this question has come, just it may happen like that. It may not be very relevant also for your case. But then, since it has come, it's quite interesting question. It is
Very, very interesting.
Well, otherwise we will do one thing. We'll omit that part because if that should not be taken as the main thing also.
No, it's okay, my lord. It is all right, my lord.
It is all right.
Yes. Okay. Dip your pen.
Item number 12.
You said list after a week. No? You already said list after a week.
Dip your pen.
Yes.
May please, Lordship. Lordship, I pray this matter may be adjourned for a day, Lordship.
My lord, in this matter, I have a little objection, my lord.
You should not have a little objection. Objection should be a big objection. Why
My
little
lord,
objection?
my lord will kindly appreciate. This matter came up for hearing on 6th of February 2024. Nobody appeared for the state. 27/2/2024, state prayed for time. 20th March 2024, state prayed for time, almost after a month. 12 April, again, almost after a month, state prayed for time. 8 May, state prayed for time. And
Okay,
the convict,
we'll reject his plea. Start it.
and the convict is, my lord, the convict, the
It's all right.
sentence
It's all right.
is,
We are rejecting his prayer. You start it. We'll take it up.
he's not the conducting counsel then.
Anyway, he'll reply will come these things. You can start. We'll just see. Because this is for your thing. So, who is appearing? Mr. Kharwanlang, who is appearing here?
Lordship, the learner Additional Advocate General, Mr. Khal Khan.
Mr. Khan.
Yes, Lordship. I've already informed them.
Go
But
ahead,
then
please, and
due
you
to some
are
difficulty,
competent enough to take note of the thing, and then you can manage it also. But then since he is objecting to the adjournment, so
Lordship, if can
she's
be
taking instance
part,
at
if
many
she can
occasions.
start today, I can conclude on the next day, Lordship.
Hearing would be better if it is concluded on the
Definitely
same
on
day.
one shot, it is always better.
My lord.
But then, madam, you are already pointing out so already so many times you have granted time also.
My lord, 6
So
times.
it doesn't look proper for the court also, you see.
Indeed, my lord.
So we'll just start. We'll go ahead.
My lord. If I may take your lordship to the FIR, my lord, the typed copy at
Just-
page 3.
Just a minute. You are a legal aid counsel here?
Yes, my lord.
Conviction is for how long, madam?
Conviction is 7 years, my lord.
Sexual offense.
No, my lord. It is a grievous hurt.
Okay. 326.
Yes, my lord.
Yes.
If I may take your lordship to the FIR, page number 3.
Yes.
We, the family members of Shri Banshemphang R. Marak, son of Shri Nit Linkoi, resident of Saiden, we hereby lodge an FIR against Shri Makhon Magdaw of Yeo Molong for he stabbed with a knife from his stomach last night, the 21/11/2017, at around 10:30 p.m. at Yeo Molong Junction, while he was coming from the house of Shri Coming Soon Kharshande, who is the owner with whom he is working. We took him to Civil Hospital Nongpo, and then he was referred to Nigrim's Hospital Shillong, and he was kept under ICU.
Please read it again. Court did not get the meaning, please.
My lord, basically what had happened is the accused person herein was driving a truck, and he had come to a halt at Yeo Molong Junction, the convict, and
Makhan Magda, he is the accused, isn't it?
Differson Magdo and Makhon Magdo is one and the same person, my lord.
Just one.
Makhon Magdo is the nickname of the accused.
One second. Just a minute. He stabbed whom?
My lord, the victim.
Who is the victim?
The victim, my lord, he was driving
What is
an
his name?
My lord, his name is
In the FIR, has it been reflected? No.
no, my lord.
In the FIR, it has not been reflected.
Banshemphang R. Marak.
So that is where. But then you see, like FIR doesn't say that he has been stabbed. That is why this court requested you please go through the FIR again.
My lord,
At
it
least
was
some picture we should get some picture, isn't it? So now we understand that the FIR was lodged by the family of
yes, my lord, of
Banshemphang
Banshemphang R.
R.
Marak against
alleging that Makhan Magdo has stabbed him on
such and such date.
at Yomalong Junction.
Yes, my lord.
While he was returning from his owner's place, isn't it?
Yes, my lord.
Okay, so Makhan Magdo is a driver.
My lord, he is the auto driver, and this Kamingsun Kharshandi is the owner of the auto.
Okay, now the court got the picture. Now you can
My lord.
proceed.
Now,
It is very important to get the facts, you see.
Indeed, my lord. Without facts, my lord, a criminal case, absolutely we cannot understand anything.
Yes, please.
So, my lord, when this accused person was coming from this owner's place, he was along with his 2 to 3 friends more.
But that is not been mentioned here.
My lord, I'll take your lordship to
it's okay,
section
it's
under
all right. You
164.
just finish it.
This is just the
These
background.
are the matters of fact. You see,
My
then
lord.
what you show us later, we'll see.
My lord, this is just the background.
Yes.
So, this coming soon Kharshandi, sorry, my lord, the accused person was coming along with his 2 to 3 friends. When he reached Yomolong Junction, he saw the accused person in the truck and he stopped his auto rickshaw out there. Thereafter, these 3 people, the victim as well as his 2 to 3 friends, they all came and attacked the accused person. They used slangs and they tried to hit him as well. So in private defense, the accused person
Was there a counter FIR?
no, my lord, counter FIR was not there.
So on what basis you disclose this?
My lord, on the basis of on the basis of the statement recorded under 164.
So your plea of self-defense,
My lord.
164 statement of whose? Your
Yes, my
statement.
lord. Yes, my lord.
So your plea of self-defense was first disclosed in 164 statement.
Yes, my lord.
But then, therefore also you did not file any FIR.
My lord, FIR was not lodged.
Okay.
My lord, illiterate people, so they did not.
Okay, we just
Now,
tell
my
us the
lord,
fact.
if I may take your lordship to the statement under 164, I'm not praying for a complete acquittal in this matter, my lord, because ultimately from 164 it is seen that yes, an act has been committed.
Certain
it is a
provocation.
private defense
Under provocation.
under provocation, self-defense, and there was no intention of hurting the victim. And more so, the accused person has now already undergone more than 6.5 years of sentence period out of 7. In November, he is supposed to be released. Now is May, June, July, August, September, October. Just 5 months is left, my lord, out of 7 years. My lord, if I may take your lordship to the statement under 164 at page 103.
Was it exhibited before the court?
Yes, my lord. It was exhibited as Exhibit P11.
Okay, 164. First you are taking to the statement of the accused.
Statement
under
of the
164.
accused under 164.
Where is that statement? What page you said?
Page 103. The effective portion of the statement starts from page number is at page number 106.
Yes.
Page 106, my lord. The statement.
Yes.
I was returning back from my work and it was late at night. I came from Guwahati and I was proceeding toward Umsning to unload the rice which was loaded in the truck. On reaching Paham CM, I stopped the truck as I wanted to go to my house while giving pass to one car. The front tire of my truck got stuck. I could not remove my truck as it was a slow. I went looking for help. I could not find anyone, so I came back to the truck. I tried restarting the engine with the hope to get the tire out of that hole. In the meantime, one auto rickshaw came and stopped in front of my truck. 3 men, namely Babu, Hepna, and one more person whose name I do not know, got down and came towards my truck. I got down and we started talking. They asked me about Badeng, who was the actual driver of the truck. I told them that Badeng had gone home. After that, they started assaulting and beating me. 2 of them were assaulting me, namely Babu and Hepna. As I was alone, I took a knife from the truck to defend myself. In the process, I cut Hepna from his stomach as they were still assaulting me. I had no intention to hurt anybody, but I was just trying to defend myself. Since Hepna came ahead, the knife got a portion of his stomach. I did not stab him. It was a cut as I was moving the knife to keep them away from me. Later, I took Hepna to the auto after he got injured, along with Babu, and he was taken to the hospital. My lord, if this accused person would have had any intention to commit an offence against anybody, he would not disclose these things before the learned magistrate.
Now, you said that you were attacked first,
Yes, my lord.
and that in self-defense you took a knife.
Yes, my lord.
Now, immediately after the incident,
My lord.
whether you were medically examined or not, what was the injury on your body at the time when this incident took place? Now, it appears that you have taken a
My
drastic
lord, there is medico-legal report is only of the victim. There is no medical report or no medical examination done of the
there is
accused.
nothing to show on record that you were even assaulted also.
My lord, but this statement made before the learned magistrate, this has not been put into question during the cross-examination or by the prosecution.
It is not required. You see, it is not required that your version will be accepted, because this will go as your defense version.
My
Okay. So defense version depends upon acceptability.
My lord.
So that is it. Now this question is that, don't think that the court has discarded it.
Indeed, my lord.
Now what thing is this court wants to know whether there is anything on record to support your statement or not. And what can support your statement is that if there exists any medical report. So supposing, see, here it's a case of 326.
My lord.
Not case of 320 or 325.
Yes.
Isn't it? So 326 grievous, as you see, 7 years thing. It's quite major punishment. Now when you take that much severe, you see, step to defend yourself, that is, it is assumed that something very serious must have occurred. It is not that just for getting a slap, you see,
It was
return
not
it
a
by.
slap. Definitely not, my lord.
So it is what? So to establish that you were also assaulted, probably, you see, like we expect that there will be some medical report to say that.
My lord.
So nothing on that. So there is no medical.
Not been examined.
Okay.
Now, my lord, apart from that,
So at least you did not need any medical attention there and there. There was nothing to
yes,
show.
my lord. Since he himself has dropped
Yes.
the accused person till the auto and he has taken the victim to the hospital as well. So if there would be something very, very serious at that point of time, it might be an internal injury which might not have been visible at that point of time, and the pain might be later, my lord.
Anyway,
That is possible. Now,
the extent a defense counsel can go, huh? That is, see, the principle is that never say die, you see, like.
now, my lord, one more point, my lord. This case is not just 326, 307 has also been added.
Okay. And then conviction was recorded under 307 also, against 307 also.
Yes, my lord.
You are punished for 326, 307 also. How long this victim was in hospital
My
after
lord,
the incident?
Victim was approximately, my lord, 1 week, to my knowledge, as far as I remember from the records.
And what is the requirement of law to establish grievous hurt?
My lord, grievous hurt exactly.
See, it cannot be something like that. Anybody comes and says that, you see, like I have received grievous hurt.
My lord.
There is some ingredients to it. Now, maybe, well, this court doesn't know. It doesn't want to give you any hint also. But then probably these questions are coming to the mind of this court. Is it required that to establish that someone has received grievous hurt, whether he will have to be treated as an indoor patient in a hospital, and for how long?
That is
Do you have any idea of that?
We cannot
Anyway,
say that. It
so
depends
your
from
argument
case
is not,
to case.
Your argument is not based on those things.
My lord,
right,
that
all right.
question definitely did not come to my mind. Otherwise, I would bring some
Probably
materials. to
there
that.
are certain things, there are basic things, there are something elementary basic things. If you want to dispute that somebody has received grievous hurt,
My lord.
then you have to see what are the ingredients which constitutes grievous hurt.
Lord, in this matter,
And once you follow this, then this will automatically come.
Ma-
Probably. Court may be incorrect also. Okay.
But my lord, this is one food for thought. It requires some thought, and it should be dealt with.
It's up to you. The court would not.
No, my lord. This
court would-
is
see, this is your case. You know the best way to establish it.
indeed,
Isn't
my
it?
lord. But if a genuine question, my lord, though in India it is not an inquisitorial system which is being followed. It is basically adversarial, or it's the council. Or I might have mistaken the terms, my lord.
Well, the court is getting it difficult to understand what you are trying to say.
My lord, generally the court hears whatever is placed before the court, and on that basis the decision is given. But at times, in such type of
Not
cases, there is a
necessarily. You see,
requirement.
we have a law in place,
My lord.
and if law lays down certain criteria, then definitely you cannot say
We cannot
that the
override
court
that.
overlooks that and just goes by merely statement. You cannot.
Cannot. And
Okay.
my lord, so far as this particular aspect that your lordship has just pointed out, that grievous hurt, how many days minimum should he be in the hospital, if there is any particular law that has been laid down prior to that.
Exactly. That is
So that needs to be placed before this honorable
grievous
court.
hurt means something quite threatening. It
My
may be life threatening also.
Yes, my lord.
Okay.
That is why 307 has come.
So just mere receiving injury and coming later on coming with the allegation that I have received grievous hurt and getting somebody punished for 7 years with that allegation.
My,
You see, it cannot be on the basis of flat allegation and the basis of statement.
my lord. And the
Somebody
medical
comes and says that I have received this much injury, Miss Agarwal has hit me with this thing.
my-
At least to establish that I have grievously hurt, then I have to put on some medical record
reports has to be there.
which would say that I received grievous hurt. And that is not
So
on
far
my
as-
statement.
So far as the victim is concerned, my lord, the medical reports have been exhibited, and it shows that stabs were there. So far as the victim is concerned, stabs were
So
there.
you are satisfied
So-
that there is grievous hurt. You are not disputing that part.
No, my lord. That part we are not
Then
disputing.
if you are not disputing, then
It is a grievous hurt, but the most important part, my lord, in a criminal case, as your lordship is well aware, the two most important ingredients are mens rea and actus reus. In this particular case, we can see that there is an actus reus. That is how he
there
has
is no
got
mens rea.
hurt.
There is no mens rea.
But there is no mens rea.
That is what your case is. So
Yes,
you want to say this will come under, fall under something, what is that, say 335, 336 or something? Mr. Gurung, what is that?
326,
Still-
madam.
No,
326
provocation,
has
under
been-
provocation.
It is under provocation. So private defense
It should be
will also
332,
come.
33, 34, 35 something. Mr. Karwanlong may find it out.
But
Anyway.
my lord, in this case, kindly see, both 326 as well as 307 is attracted very
Yes.
much, my lord. For the fact that, my lord, has to just look into the nature of injury, my lord.
Okay, we'll just see it. But then she said that she is not disputing that.
Right.
So far as the heart is concerned, the gravity of the heart is concerned, she is not disputing that. So we will not go into that question. Once she is not disputing that, why should we use this thing? So 326, we can write that 326 is not
Hurt
disputed.
is there, my lord.
It is not disputed.
My lord. Grievous hurt is there, but to convict a person under any of the provisions of IPC or any other criminal law or any other special law, the mens rea as well as motive.
That is, you
These are two things which need to be categorically proved. Now, the prosecution has brought the statement under 164 before the learned trial court. The statement was also recorded by the learned magistrate upon the police forwarding the accused person to the magistrate, and he was given sufficient time and he has thought over it and he has told the absolute truth before the magistrate. Now, my lord, when I went through the statements under 164 and 313, section 164 statement was recorded during the period when investigation was going on. Now, in that particular statement, he has stated that in private defense, I was just trying to keep the victim and his friends away from me by waving the knife in front of me so that they stay away. In that process, the victim came forward and that is how he got hurt. Now, my lord, this particular...
She can create scene also.
Lord, this particular 164 statement,
Yes.
in my humble submission, is more reliable than the statement made under 313. Reason being, my lord, at 164 stage...
See, 313, why you are drawing a comparison?
My lord,
313
I
is
am
not
doing
at all, not at all a piece of evidence.
It is not a piece of evidence, my
Where
lord.
is the question of drawing a comparison?
My lord, the reason...
313 cannot be relied on solely to base conviction.
My lord, solely to base conviction, it cannot be relied upon.
Can be.
Yes, my lord. My lord, that is why I am relying on 164 more, in spite of the fact that in 313 there is a retraction.
313 you have retracted.
There is a retraction, but my lord, there is not a complete retraction. The retraction is only to the extent in 164 he says that yes, I used a knife. In 313 he says I did not use any knife. There was no knife with me. I was simply using fists and blows. So, my lord, fists and blows cannot lead to a stab when the medical report is clearly establishing
But
that.
then you are not disputing the part of grievous hurt.
My lord,
So it doesn't matter whether it's a cut mark or not, you see. So it doesn't matter. This will not alter the situation under 326.
My lord,
Now,
this will,
if we can
this
understand,
will to some extent alter
see,
the situation.
kindly, I do not know which way your argument is directed. Now, if you say that your basic aim is to establish before the court that there was no mens rea.
My lord.
Okay.
My lord, that is my first point.
And whatever has happened, it is because of extreme provocation and in order to safeguard himself from the attack. Now, if that be the thing, then you see, like whether there was a use of knife or no use of knife, whether you restricted on 160, may not be that relevant in view of the fact that you are not disputing 326.
When I am on mens rea, I am arguing this, my lord. Apart from mens rea, there are two more grounds, my lord, which are important. My lord, along with the victim, there were two people, as has been revealed by the accused also in his statement under 164. Now, these two people have been have deposed before the learned trial court as PW2 and PW3.
This Hepna and somebody else, yes.
Hepna is the person, my lord, who is the victim. That
Okay.
Babu and the third person whose name the accused did not know, they have deposed before the learned trial court. If I may take your lordship, my lord, in brief, why the statements of these two witnesses are important is both the witnesses.
We'll read the entire set of them.
My lord, I'm just giving a crux. These two witnesses, my lord, PW2 and 3, they have deposed that they do not know who assaulted the victim. My lord, they were present with the victim. One person says, I was on the other side of the truck. One person says, I just heard shouts of help. So, none of them, there is no eyewitness in the case in spite of three
Then
people
which
getting down
which
from
way
the
that part of the evidence helps you when you are not denying the occurrence?
My lord, the occurrence
Can
is
you
there.
maintain two set of arguments?
My lord.
One saying that it was done under extreme provocation, And second, you come with some evidence saying that, you see, the entire occurrence is disputed.
No, the occurrence is there, the hurt is there, but who caused the hurt? If we go by the evidence, the depositions before the learned trial court, we do not know who has stabbed the victim. But in fair transparency, I am placing this particular statement under 164 before this honorable court because the statement under 164 has not been challenged before the learned trial court. And once the statement under 164 is not challenged before the trial court and the magistrate has duly deposed before the learned trial court that all due procedure was followed, Lord, in such circumstance, we cannot discredit the statement recorded by the learned chief judicial magistrate.
What happened to the thing? What the impugned judgment says? They discarded the 164 statement. What is the observation of the trial court with regard to 164 statement?
My lord, I've just
Take
the
us to
accused at page 130.
130.
This is the analysis of the evidence on record.
What is the come to the particular? See, we'll have to go to the judgment also.
My
But
lord.
then let us see which way the court has dealt with 164 check.
164, my lord, at paragraph 10.
Yes, please.
The accused in his confessional statement admitted to have injured the victim in his stomach, though he claimed that they were 3 against 1, out of whom 2 of them assaulting him, hence in self-defense that he had taken a knife from the truck and in the process that he cut the stomach of victim without any intention to hurt him. At this point of evidence, even the PW12, a magistrate who recorded the confessional statement of accused at Exhibit P11, who is a well-trained judicial officer, well conversant with the requirement of the provision of Section 164 CRPC, and her fair recording of the confessional statement of the accused person, which is not disputed from any corner about her compliance with the formalities as required under Section 164 CRPC. Hence, her recording is not questionable nor doubted. The defense, while cross-examining the PW12, simply tried to discredit her evidence being a refreshed version after going through the statement in court, but the recordings at Exhibit P11 itself was not able to be toppled by defense from cross-examination of PW12. Thus, the recording of confessional statement of accused at Exhibit P11 remains unchallenged, which can be safely presumed to be true and genuine confession of the accused to the fact that he, being challenged by 3 persons, had taken the knife from the truck and mistakenly cut the victim in his stomach, though with his statement that he had done so in self-defense. The statement of accused under Section 313 CRPC, changing his version to the mistaken stabbing by victim or his friends and not by him, is a statement which seems exculpatory statement which cannot be accepted as true fact, since the stabbing on the person of the victim, as per medical evidence on record at Exhibit P6, as proved by PW7 Dr. P. Taryang from Nongpo Civil Hospital, who deposed that he noticed 2 stab injuries on the left side of the abdomen and 2 on left upper back, was corroborated also by medical evidence at Exhibit P7 proved by PW8 Dr. Intekab Alam from Nigram's Hospital, Shillong, who deposed that victim was having multiple injuries on left side of the chest and upper abdomen, which evidence is proving that victim will not mistakenly stab himself more than once and his friends will not stab their friend more than once, especially when they did not hesitate to help him reach the hospital immediately after the incident. Hence, the evidence of victim PW4 that he was alone with the accused at the time of stabbing incident and that he was holding the hands of accused to prevent him from further stabbing seems to be a true narration of fact which accused could not explain as to how victim or his friends will stab the victim more than once. Hence, the confessional statement of accused person under Section 164 CRPC at Exhibit P11 is presumed to be the truth as confided by accused before PW12, which facts to the Commission most admitted by accused in his statement recorded under section 313 CRPC that are taken as inculpatory statement, while his reverse in the form of denial thereto is taken as exculpatory statement, which are ignored by this court, since accused could not satisfactorily explain as to why he confessed under section 164 CRPC that he had mistakenly cut the stomach of victim. The presumption of his denial in his statement under section 313 CRPC as exculpatory statement, while his admission of certain facts like being provoked, which corroborates his admission under section 164 CRPC, is presumed as inculpatory statement, is relied from the authority by Nishikant Jha versus State of Bihar, in which the Honorable Apex Court has held that the exculpatory part of the appellant's statement was not only inherently improbable but was contradicted by the other evidence, and also it was wholly unacceptable. The other incriminating circumstances considered along with the appellant's statement pointed conclusively to his having committed the murder. The court could reject the exculpatory portion of the statement and accept the inculpatory portion.
It doesn't let on a propositional flow. That is dependent on the factual aspect.
That
the
is
apex court judgment which has been
my lord,
relied upon.
I was just about to state that this case was a case of murder and separate.
Anyway, see, but then
my
one
lord,
thing.
the section 164 statement, in my humble submission, has been accepted by the learned trial court to be true. So once the statement under 164 is accepted by the trial court in its totality, and I am standing before this honorable court stating that it is on the basis of 164.
So far, it is in the discussion in the court. Now, confessional statement.
My lord.
So far, it relates to the confession of the commission of the crime. That may be accepted. But then, when it, you see, basically, what to say, raises allegation in others, that may not be accepted.
That may not be accepted because that is exculpatory.
So, if you say that it has to be accepted in totality.
My lord, regarding the exculpatory portion that somebody else had stabbed, that is nowhere there in the 164 statement. It is nowhere there. In 164 statement, the accused has maintained his stand that the three of them were against him alone. He did not make any statement against the other two persons who were along with the victim. There is no statement against them.
See, 164 is this not the sole basis.
It's not the sole basis, but my lord.
But then at least it supports so far as the accusation against you is concerned. Now that is what.
And my lord, in my humble submission, my lord, this 164 statement is still a confessional statement. He is confessing that yes, I have done it. I do not have a copy of the judgment with me right now, my lord, but the decision passed by the division bench of this honorable court, it was an appeal preferred by the state. It was a case of 302, and the sole basis of conviction, converting the acquittal to conviction, that too for life imprisonment, the sole basis was the statement under 164. Now, in that matter also, I was appearing for one of the accused persons as a legal aid counsel, and my lord, there were two accused persons in that particular case. The statements made by the two of them.
The old case, it is
my lord, the Bernard Lingdorp Hawa. Your lordship will recollect. This is the victim was a student of Saint Anthony's College, my lord.
Yes.
That matter.
Biplab Kumar Dev, something.
Biplab Dev, my lord.
Yes.
So in Biplab's case, my lord, this Bernard Lingdorp Hawa as well as Bonnie Lingdorp Hawa, they both have been convicted solely on the basis of the statement made under 164. And in 164, Bernard is implicating Bonnie. Bernard says that when I entered the graveyard, Bonnie was strangulating the victim with a rope. Bonnie says...
That is a statement made under 164.
164, my lord. Bonnie says that all the three of us were drunk. Bernard had gone out to buy cigarette. In the meantime, Biplab was absolutely drunk, the victim. That is why he was lying on my lap. When he was lying on my lap, I realized that he is not breathing. So, my lord, there is no confession. Bernard also does not say that I killed or I attempted to kill the victim. Bonnie also does not say that I killed the victim. Bonnie says he was merely lying on my lap and he saw that he has expired. Bernard also says that he makes an exculpatory statement. There is no inculpatory statement. My lord, these two statements were both under 164, and solely on the basis of this particular statement, the conviction has been made
Now,
of life imprisonment.
while accepting those statement, one proposition was laid down by the division bench of this court.
My lord,
What
the
proposition? Was it basis of certain proposition?
my lord, the only reason why
Today, in my 164 statement, if I say that Miss Agarwal has committed some crime, can it be made a basis for convicting you?
cannot be, my lord. There has to be
Now,
some proof.
So that is what. Say, if you say that what is happening, what has happened to that division bench case, and the proposition laid down there may apply here. So in such a case, you just tell us what is the proposition there.
My lord, in that particular case, the only reason on the basis of which the accused persons were convicted was that there is no disputed question of fact that the three of them, the victim and the two accused, were at the same place and at the same time. In spite of the fact that, my lord, I'm going a little bit beyond, my lord, there was a post-mortem report in that particular case which stated that the victim had expired 72 hours ago, whereas by the date of the occurrence, if we see, it was coming to.
But that is okay. That is so far as that case is concerned. Which
Yes,
way
my lord.
related to this?
In this case, my lord, I am relying only on the portion of the 164 statement.
You want to say that it has to be accepted in totality.
My lord, in this particular case,
Your thing is that once inculpatory statement is accepted, then exculpatory statement also has to be accepted.
no, my lord. Exculpatory is not to be accepted. I am not saying that, my lord. My prayer in this particular case is only to the extent that this particular accused person did not have any intention, no motive, no mens rea. It is only the actus reus part which is there. So my prayer is not of an acquittal before this honorable court.
We will determine after we go through the entire.
My lord, my prayer in this particular case is very small.
The victim was examined in this matter.
Yes, my lord. The victim
had given a
deposed.
deposition.
Victim had deposed before
What is the
this
deposition of
honorable court.
victim?
PW4. Page number 30, my lord. 30. Victim is saying that the accused had stabbed him.
Let us see under what situation, what
Yes, my lord.
circumstances he narrates.
Yes, my lord.
Page 40.
30. 30.
Yes.
I have received the summon to depose before this honorable court today. I am
Oh, madam, one second. You can do the way you want to do it also.
My
It is
lord.
not that, but then it may be very relevant.
Yes,
if you
my
have
lord.
something to present in your way, you can do that.
My lord, let us go with the flow for the time being, and if there is something more relevant which comes in between,
Yes.
I will go to that after this. I have received the summon to depose before this honorable court today. I am a resident of Saidan Nongkindang village, and at present I am unemployed. I have come to depose today regarding the incident which occurred on 21/11/2017. On the day of the incident at around 9 p.m., myself along with my friends known as Nak and Babu went to Masjid locality in the auto rickshaw to meet my employer coming Kharshandi for handing over the money. Unfortunately, my employer was not present. As such, myself along with my other two friends, we returned back home, and on reaching Yomolong Junction, me and my friends saw one truck which was dashed against one tea stall. On seeing the said truck, I stopped the auto rickshaw driven by me, and all of us we got down. The two friends of mine They went towards the left side of the truck to inquire about the incident. Whereas myself, I climbed the driver's door of the truck and I saw the accused person, who is known as Makon. He was sitting in the driver's seat, raising the accelerator of the said truck in order to remove the said truck.
So they are known. That means they are known to each other.
Yes, my lord. The accused person had also mentioned the names.
Yes.
The accused person was alone inside the said truck. I asked him why did he drive the said truck, but he was silent. Thereafter, I got down from the said truck and the accused person also got down from the same. Then I asked him why did he act smart by driving the said truck when he do not know how to drive the same. Again, the accused person was silent. The accused person with his hand at his back, and at that time when I faced at the truck, he was behind me and he stabbed me from my left side of my chest. I am certain that it was the accused who stabbed me. The accused person pulled me and at the same time he stabbed me 4 times and I could feel the blood was coming out and even touched the injury part and I felt helpless.
He was stabbed for 4 times. Even the medical also confirms it.
Yes, my lord.
In your self-defense, you have stabbed in 4 times. It's all. Carry on. Go ahead.
At the time when the accused person stabbed me, I asked for help by saying yarap yarap, and I also hold him in order to protect myself from further stabs. Thereafter, my friends, they heard my cry for help and both of them came towards me and they lifted me inside the auto rickshaw and took me to Civil Hospital Nongpo. I was conscious at that time and I know that I was being taken to Civil Hospital Nongpo by my friends. As soon as I reached the hospital staff gave me treatment and they covered the injury part of my body in order to protect the bleeding. Thereafter, I was taken to Nigram's Hospital, Shillong for further treatment. At the time of the incident, only me, my other 2 friends known as Nak and Babu, and the accused person were present at the place of occurrence. Till date, I still suffer frequent cough and pain due to the injuries. The mark of injuries could also be seen in my body till date. On the day of the incident, I was wearing a grey shirt with few black stripes and I identified it in court today in front of the accused person and in presence of the learned defense counsel and the prosecution, which is marked as Material Exhibit 1. Due to my severe pain, I do not know who lodged the FIR in respect of the incident. The police visited me at Nigram's Hospital, Shillong and recorded my statement, and I have stated the same thing which I have stated before this honorable court today. The accused person belongs to another village, but I know the accused person by face since I am the auto rickshaw driver. I know the accused person and he is standing in the court dock today, crossed by the State Defense Council. I do not remember the registration number of the auto rickshaw, but the auto rickshaw belongs to Shri Cumming. We are having 11 brothers and sisters from the same mother. I know Shri Lapinhun R. Marak. He is the son of my auntie. I know Shri Vanprangsni Siemlie as he is staying near my house. I do not know the real name of my friends who accompanied me on that day of the incident. It is a fact that I know Lapinhun R. Marak by his real name and I know Vanprangsni Siemlie by his real name and I can recollect now their real names after being mentioned to me now. It is not a fact that I did not go with Shri Lapinhun R. Marak and Shri Vanprangsni Siemlie. It is not.
Are they this means
These
he's
two are
referring to
the
this
friends.
Nak and Babu.
Nak and Babu.
Yes.
It is not a fact that there is another person who accompanied me on the fateful day other than Lapinhun R. Marak and Vanprangsni Siemlie. It is a fact that the accused person told me that he was not a driver of the said truck that got stuck at the place of occurrence. When we saw the truck at the place of occurrence, I went to see the driver, but instead I saw the accused person sitting on the driver's seat. And when I inquired from him why you tried to drive the truck when you are not the actual driver, but he did not reply anything, he just told me that he was not the handyman of the truck in question, but he was the handyman of another truck. It is a fact that I did not see anything in the hand of the accused person as he was holding his hand behind his back. It is not a fact that I seek help from the accused person. It is not a fact that the accused person did not stab me. Though it was dark, I can assure that the accused person stabbed me because after he stabbed me, I hold both his hand so that he will not repeatedly stab me, and I called help from my 2 other friends mentioned above. When they come to help me, I let go of the accused person. Material Exhibit 1 was removed from me at the hospital. I have no enmity with the accused person even prior to the incident. I am the uncle of Sri Lapinhun Armarak, and Sri Vanprang Sni Siemle is my co-villager. Now, my lord, there is one contradiction between the statement of the victim in his chief and the cross. In his chief, he has stated that the victim, the accused, stabbed him from behind. Whereas in his cross, he has stated that as soon as he was stabbed once, he held both the hands of the accused. Now, my lord, if the accused person was behind him, how can he hold both the hands of the accused? It is
You have not put even a suggestion question that the accused had never stabbed him. It is not your case. You have see your cross-examination. There is no single question.
My lord,
to that aspect.
there is, my lord. If your lordship kindly sees paragraph 14.
Yes.
Though it was dark, sorry, my lord, paragraph 13. It is not a fact that the accused person did not stab me. Suggestion was put, he has denied, but in the very next statement, he has stated, I can assure that the accused person stabbed me. He did not see the accused person stabbing. He is making contradictory statements. Once he says that the accused is stabbing from behind.
But then he was holding your hand.
Second statement, he is making that I can give an assurance that it is only the accused who stabbed me. If the accused is behind, he cannot see the face, so the assurance comes.
Then how he?
Sorry, the assurance does not come.
How he came to hold your hands?
Exactly, my lord. The chief and the cross are contradictory to each other.
Okay. Okay.
So a presumption, a doubt is still there as to who has stabbed the victim. The victim himself has not seen the.
But then you are not denying it. You said you have done it under extreme provocation.
My lord, 164
now,
still stands.
Now, so far as your entire cross-examination is concerned, not even a single question. How you see, like you were provoked.
My lord, on the provocation, I admit there is no question.
Probably, I do not know which way. That is you are the best person how to do this. But then say like the very start of your argument, and you said that you are not asking for a clear-cut acquittal, and you were just trying to establish a case that there was no mens rea, and then whatever has been done was done in self-defense, and there is no absence of mens rea.
My lord.
But then your entire cross is not even directed to this. You see, in view of the stand which you take it, this minor contradiction will lose its relevance.
My lord, stabbing from behind, stabbing from front.
The fact remains that
there is a grave
the fact
difference.
remains that he has received 4 steps.
My lord.
See,
the fact remains.
That is what. Anyway, let us see the other thing. This what is this?
PW2 and 3.
Nakan and what is what is his name? Nak and Babu.
Yes.
Where is Nak and where is Babu?
My lord, I do not know who is Nak and who is Babu. Okay. I just know the good names.
It's okay. That's just.
So it's PW2 and PW3.
They were examined before the
learned trial court.
Yes, they were examined before the victim, isn't it?
My lord.
Victim is PW4, isn't it?
Yes, my lord. Victim is PW4. PW2 is Vanprang Ski. WCMLA.
PW2.
PW2 WCMLA.
Yes, page 1.
Page 21.
Okay.
I have received the summon to depose before this honorable court today. I know Shri Banshimprang Armarak. He is my neighbor and he is also my friend. On 21/11/17 around 9:30 to 10 p.m. I was with Banshimprang Armarak and Lapinhun Armarak. At that time, all 3 of us went by one auto rickshaw driven by Banshimprang Armarak to the house of the employer of Banshimprang Armarak at Masjid to give him the money. The said owner was not present, so all of us returned back, and on reaching the Yomolong junction, I saw the truck, which was usually driven by my brother, has dashed one grocery shop. Banshemprang R. Marak stopped the auto rickshaw. All of us got down from the auto rickshaw and headed towards the truck. Me and Lapinhun R. Marak were inspecting the damage of the truck and the said shop, whereas Banshemprang R. Marak went to the driver's side of the truck. Suddenly, I heard the noise of Banshemprang R. Marak seeking for help by uttering, asking for help, yarap yarap. Immediately, myself along with Lapinhun R. Marak, we rushed to the driver's side, and I saw Differson Magdo, accused, was standing next to Banshemprang R. Marak, and I also saw Banshemprang R. Marak was bleeding from the stomach. I could see that the blood have profused immensely from the stomach portion of Banshemprang R. Marak, victim. At that time, Banshemprang R. Marak was covering his stomach with both hands and in a bending position. Myself and Sri Lapinhun R. Marak, we asked Differson Magda to help us to take the victim to the hospital. The accused refused, and instead he fled away. Myself and Lapinhun R. Marak took the victim inside the auto. At that time, the engine of the said auto did not start, but we managed to push the said vehicle, and thereafter we rushed the victim to Nongpo Civil Hospital. Later, the relatives of the victim was informed. The police have recorded my statement, and I have stated the same thing which I have stated today. The seized material was produced before this court from the court's Malkhana. With the permission of the court, it is open in front of the accused person and in the presence of both the prosecution and the defense counsel for identification and verification. Material Exhibit 1 is one grey color t-shirt of Sri Banshemprang R. Marak having 3 block line stripes on both shoulder till arms. The t-shirt had blood stain on it, mostly on the left back portion. It also has 2 cut marks on the left back portion of the t-shirt, 1 cut mark on the left chest portion, and 1 below the ribs portion left side.
You can skip this. Skip the. I think those might not be much relevant. So far as this
Statement was recorded before police and before the magistrate as well, and then before the court. That is all in the chief. Coming to the cross-mala.
yes.
The occurrence took place at night time. At the time of the incident, I was at Yomolong village. The truck was proceeding from Guwahati towards Shillong. It is a fact that I did not travel by the said truck at the time of the incident. The truck was driven by the accused person. It is a fact that I did not travel by the said truck at the time of the incident. The truck was driven by the accused person. I was not inside the truck when the accused person driving the truck. It is a fact that I found the said truck had already dashed towards the shop of Srimati Kret Mopnyang. When I, along with my co-villagers, passed by the side of the shop of Concrete Mopnyang, found that the truck had dashed on her shop, so we stopped to see, and especially the truck driven by my cousin brother, and I am more concerned to see what happened. On the day of the incident, my cousin brother Sri Bisharlang Siemlie had already parked the said truck in the roadside near the football ground, and then he went home. Before my cousin brother Sri Bisharlang Siemlie, which we used to call him Deng, went home, he left some food for the accused person, as the accused person halfway boarded the truck. When I went near the accident site, I saw the accused person was sitting on the driver's seat. I did not witness when there was a fight between the accused and the victim, but I heard the victim call for help. It is a fact that I do not know who assaulted the victim. It is a fact that I just helped the victim to take him to hospital. I do not know the reason why the accused and the victim were fighting. Re-examination by additional PP. It is a fact that when I saw the victim, I saw his one hand holding his stomach and the other hand he grabbed the accused person. At the time when I rushed to see the truck that was dashed against the shop of Srimati Kret Mopnyang, I saw the accused person was sitting on the driver's seat and trying to release the said truck from the accident site. At the time of the incident, there were no other person who were present except myself, Lapinhun R. Marak, Banshemprang R. Marak, and the accused person. Question put by the court. When we took the victim to the hospital, he could not speak anymore. I am sure and confident that the accused person assaulted the victim because when we reached the spot, he started to run away, and also when we called him to help us to take the victim to the hospital, he fled away. This is the statement of PW2. PW3, my lord. Page 26, the next page. I am a resident of Saiden and I am an auto rickshaw driver by profession. On 21/11/17, at around 9 to 9:30 p.m., myself along with my friends Vanprangsni Siemle and Banshemprang Armarak left Nongkindang village and proceeded to Masjid by auto rickshaw driven by Banshemprang Armarak. All of us went to Masjid with the intention to hand over the money to the employer, Sri Kamingsun Kharchandi, who was the employer of Banshemprang Armarak. On reaching the house of Kamingsun Kharchandi, we found that he was not present, so all of us we returned back with the same auto rickshaw. On returning, I, along with my friends, saw one truck which collided to one shop at Yongmolong Junction. On seeing the same, Banshemprang Armarak diverted the auto rickshaw to the service lane, and on reaching the spot, he stopped the auto rickshaw and all of us got down to inquire about the incident. Myself, along with Banprangsni, we approached the left side, handyman side of the truck, whereas Banshemprang Armarak approached the right side of the truck and the driver's side of the said truck. While me and Vanprangsni Siemle were inspecting the damage of the said truck and the shop, I suddenly heard the voice of Banshemprang Armarak, who called for help by saying Yarap Yarap. Immediately, myself and Vanprangsni Siemle, we rushed to see what happened to Banshemprang Armarak. On seeing him, I saw Banshemprang Armarak holding himself in a position which he almost fall down. I hold him from his waist and Banshemprang Armarak told me that Makhon stabbed him with a knife. I saw the blood is coming out from the left side of the waist of Banshemprang Armarak. Thereafter, myself along with Vanprangsni, we called the accused person to help us to take the victim inside the auto rickshaw, but the accused person refused and instead he fled away from the scene. Myself along with Vanprangsni, we lift Banshemprang Armarak victim inside the auto rickshaw, and I took the cloth and covered the injury portion of Banshemprang Armarak in order to prevent the profusion of blood. Then I drove the auto rickshaw and I, along with Vanprangsni, took the victim to the hospital for treatment. The shirt, which is material exhibit 1, was shown to me today, and it is the same shirt which was wearing by the victim Banshemprang Armarak at the time of the incident. On reaching the hospital, the doctor told me to inform his relative victim. So I asked Vanprangsni to wait in the hospital, whereas myself with the same auto rickshaw went to the residence of Banshemprang Armarak to inform about the incident. I, along with the relative of the victim, I returned back to the hospital. Again, on reaching the hospital, I was informed by the relative of the victim that the doctor had advised them to take the victim to Nigrim's Hospital, Shillong. Thereafter, the relatives of the victim took the victim to Nigrim's Shillong, whereas I drove the auto rickshaw and dropped the same to the house of the victim. I know the accused person. He is also known as Makhan and he is present in the court today. I am certain that it was Makhan, the accused person, who stabbed the victim with a knife on the basis that the victim himself told me at that immediate time of the incident, and also that it was only Makhan, the accused person, who was present other than all three of us. At the time of the incident, there were only me, Vanprangsni, Banshemprang and Makhan, accused person, at the place of occurrence. The police have recorded my statement. The magistrate has also recorded my statement under section 164 CRPC. Exhibit P4 is my statement and Exhibit P1 is my signature. In both the statements, I have given the same narration which I have deposed today before this court. I do not know who filed the FIR. The victim Banshemprang Armarak is alive. Cross. It is a fact that myself, Vanprangsni Siemle, Banshemprang Armarak were travelling together in the auto rickshaw. It is a fact that while returning from Masjid towards Yomolong, I saw the truck got stuck in one shop on the roadside. It is a fact that I have stated in my statement under section 161 CRPC when I reached the place of occurrence, Banshemprang Armarak already stabbed. It is a fact that I did not see who stabbed the victim. It is not a fact that Banshemprang Armarak victim was not travelling with me in the auto rickshaw on the date of the incident. So, my lord, PW2 and 3, both of them have stated that they did not see who stabbed the victim.
But then there is no question from you to show that the provocative situation was created there.
My lord, that part has not been taken care of.
That is the most important part.
My
That
lord.
is, it appears to be smooth.
It is important, my lord.
Yes. Okay. See, madam, one thing is that whatever had happened there, you cannot improve it. So you have to go by that, isn't
Yes, my lord.
it? Yes.
My lord, basically PW 2 and 3, more or less their statement is
Same.
almost the same. There is not much of a difference. It is only PW 4. He is saying that I can assure that it was the accused who stabbed me.
That PW 3 also says.
All the three of them, none of them has seen the accused stabbing the victim. But going by 164, and since that has not been challenged before the learned trial court, and the learned trial court having accepted the same, that is the only reason, my lord. Going by the entire records, it would be a wastage of the judicial time of this honorable court to just beat around the bush and just make the arguments lengthy. So going by 164, my lord, my only humble prayer is, since the intention part has not been proved, PW2, PW3, PW4, none of them have been able to show that there was a motive behind stabbing. Motive is not there. So once and it is the prosecution's duty to prove beyond reasonable doubt.
Mens rea may not be essential in all cases. Where the allegation is proved beyond reasonable doubt, the absence of mens rea will not give you any benefit. There is a proposition of law.
My lord, even
Okay.
if
Now, mens rea, we may not know each other.
my lord,
Suddenly we meet each other on the roadside, and because of something, immediately fight erupts. Then I hit you,
my lord,
okay, and then you see you receive serious injury.
my lord.
Now there, no mens rea is there. Okay.
Indeed, my lord.
So what happens? See, these are proposition of law which is laid down by the apex court. Once you these things, and probably you are very acquainted with all those things. Now, absence of mens rea is always, you see, like it will always not give a benefit to the.
In all cases, it will definitely not give a
Now
benefit.
here it appears what could understand that the accused, see, without knowing how to drive, he made a truck. He basically drove a truck which met with an accident, and probably, you see, when he faced query from the victim and others, he felt somehow, you see, like to protect himself from the accusation and all.
My lord, there is one thing. There is one thing from the evidence which can show the motive. The motive is, we went through the deposition of PW2, one Pransky Siemle. The truck which met with the accident was owned, the driver of that particular
His
truck
brother.
was his brother. It is being driven by a handyman. In such a situation,
But then he was not the handyman of that truck. He's the handyman of another truck.
my lord,
Okay.
my lord, even if he is the handyman of another truck, in order to drive a truck, the key needs to be there.
So you see,
So
these
driving.
this may not be very relevant.
My,
How
my
he?
lord, I am coming on the motive part, my lord. Why, how the provocation came, how the motive came.
See, there is nothing on record so far as the evidence before the court is concerned.
My lord,
Keeping
I'm
aside
taking to the evidence, my lord.
keeping aside 164, okay. There is nothing, not even a single question. Say, supposing, you see, by the time when you examined or cross-examined these witnesses,
My lord.
your 164 statement was on record,
Yes, my lord.
and there you had taken a plea
My lord.
that it is the victim and his friends who came, okay, attacked him first.
Yes, my lord. So the
Now,
provocation
so
part,
far as your cross-examination is concerned in this entire case, not even a single question.
my lord, in the evidence, my lord, there is a portion which says that it was being owned by the brother, and the third person has driven the truck. In a way, we can say a third person has driven the truck. So if just a hypothetical example, my lord, if my brother's car or truck is driven by a third person without taking consent, automatically I will be provoked and I will assault
But then
him.
he has not done it. PW2 has not done it. It is a PW4.
My lord,
Your
164
self-defense is against PW4.
My
You
lord,
have not
no,
caused.
my lord. My 164 clearly says 3 of them were against one, and the trial court judgment also
See,
says the same thing.
the fact remains. Anyway, these are. There is no question of basically raising all those things. Okay, we have taken due note of all those things.
So the provocation part, my lord, in my humble submission, the provocation part is due to the fact that PW2 was the friend of PW4, as a result of which PW4 stopped the auto rickshaw in front of that particular truck. Otherwise, they might
You are
not have.
all these things you are saying without a single materials on record. You should have established it in evidence. Just telling a story will not help.
Indeed,
You see, even to allow this court to record it also, there has to be a foundation on the record.
Lord,
Here you see your position. It is you are not standing here now as an accused as you stood before a trial court.
Indeed,
Here burden of proof is on you.
my
Burden of proof is you.
Yes, my lord.
Now, if you want to dislodge the prosecution foundation of the case, then that has to be on the basis of some materials on record. It cannot be just by uttering a story which you could have before the trial.
My lord, it was in the cross only that the provocation part has been suggested. It is not direct, but it is suggestive. If your lordship kindly takes page 24. Just for a moment, my lord.
No, see, you say something which will have bearing. You see, why to unnecessary waste time which it may not be very relevant. See, because you are a matured counsel.
Only on one
It is not that you see, like, basically do not know. A lawyer definitely derives his satisfaction from performance and all those things.
Indeed.
But then performing doesn't make a matter lengthy, you see. At least point out something which is acceptable.
Just one point. Paragraph 6 at page 24.
Yes.
On the day of the incident, my cousin brother Shri Bisharlang CMLA had already parked the said truck in the roadside near the football ground, and then he went home. Before my cousin brother Shri Bisharlang CMLA, which we used to call him Deng, went home, he left some food for the accused person, as the accused person halfway boarded the truck.
Yes.
The accused person was traveling in the truck of the cousin brother himself. And this particular witness, my lord, he's clearly saying in his cross that he saw the accused person sitting on the driver's seat. So once he has seen the accused on the driver's seat, he has more the reason. He knows that, firstly, he knows that the accused person does not know how to drive. Secondly, the truck belongs to his cousin brother. Thirdly, the truck had met with an accident and dashed into a shop. So these three things are sufficient for a provocation and to have a fight with the accused person. And the same thing has been said by the accused person, that yes, there was a fight.
Interestingly, the person who was supposed to get provoked, you see, you have not done anything against him. You have inflicted injury on the victim, but then nothing on PW. There is nothing in the cross-examination to elaborate all those things. Anyway, it's
Yes,
okay.
my lord.
We have
in
noted.
the cross, that is
Yeah,
not
we
there,
have
my lord.
noted
I
it.
admit that.
We have noted it. Anything more?
My lord, my only prayer before this honorable court is, Lord, 326 as well as 307, the punishment is up to 7 years. My lord, he has already undergone 6.5 years. My only humble prayer is the rest of the period, which is remaining till November. Just that period may be set off. He has
Provided your plea is acceptable.
My lord.
You want to say any other point?
That is my.
Now it appears that you are not denying 326, 307 and all those things.
No, my lord.
Okay.
That was not
is
denied
okay.
in 164 as well.
No, whatever you want to say, you just see. Even if you say that you got provoked,
My lord.
the question of 307 should not have been there.
My lord, there were 4 stabs.
Okay.
Probably
but
that
then,
was the
but
reason.
then, but then you are not disputing that also.
My lord, probably because of 4 stabs being there, 307 was added. And my lord, since the trial court records nowhere reveals that during the evidence I have disputed the 307. So it would not be right on
No,
my
that is all
part
right.
to argue
That
that
is-
before this honorable court.
That is all right. You see, madam, one thing, this court is very conscious of the fact that you are given to argue a case on the basis of certain facts. You see,
My lord.
you cannot improve. Neither
I
nobody
cannot-
can.
I
None of us
cannot,
can. We can improve to alter it, isn't
Indeed,
it?
my lord.
Now we have to make out a case here. Now, only thing is that the contentions.
My lord.
When you see, like, your contentions is based on various facts, existence of various facts. Now this should be placed in such a way that one supports another.
My lord.
It should not mean that one plea supports and other contradicts.
My lord.
So that is what. Anyway, okay.
The only small contradiction was there only, that stabbing from behind, stabbing from front, holding both hands. So that was a minor thing.
You see, that the same way again you are saying that you have done it in self-defense. So that is where you have said you have done it.
It has been done, my lord, but just the only thing is that
That is what the
intention
court
was
is
not.
precisely trying to point it out to you.
It is just that
You cannot
the
see,
accused,
sometimes two strands you cannot maintain together.
I cannot, my lord. And the accused has not been medically examined, so I do not have documents to produce before this honorable court.
No, since once you are not disputing that part,
My lord.
at the beginning of your argument, this court was under impression that the very charge under 326
My lord.
would be disputed by you. Okay.
But the records do not.
And then
do that.
probably Mr. Gurung had already shown these things that 326 requires some medical condition to be present specific to establish that charge, to specifically establish charge. So anyway, so we take it your case as this things, a case of a self-defense. You came under extreme provocation,
My lord.
and then you see that is what, and then your
And the
160
reason behind provocation is the truck
Yes.
part, owner being.
And you see, of course, is it been stated in 164 that they got annoyed seeing you driving and all those things?
No, that has not been stated, but
Anyway,
they assaulted.
The
That has
court
been
will
stated.
compare all those things before passing judgment. Anything more you want to say?
My lord, this is my limited submission.
Yes, all right. Yes, Mr. Gurung.
My lord, as of now, I don't have the paper book.
Yes.
But from what I could gather, my lord, my lord was.
You now do not have paper book means you.
My lord, Mr. Khan was handling this matter. I communicated with him, my lord.
You reply tomorrow.
My lord.
You may not have to do this.
Tomorrow.
Will be okay?
My lord.
Give him a chance because he doesn't. He says that he will reply tomorrow.
My lord.
Tomorrow you'll be here or.
No, my lord. Online.
Okay. See, like you'll be only limited points which
My
you
lord.
will be answered. You see. Heard in part. Give a full stop. Hearing to continue tomorrow. Give within bracket date. It would be unfair if you do not.
Indeed, my lord.
At least she needs to apply full mind.
My only prayer is set off, my lord. Nothing else.
No, this is, we should finish it, you see. And the criminal appeals and all should not remain pending. This
My
should be
lord.
given priority.
Especially, my lord, when the stay or suspension of sentence is not there. In such circumstances, it becomes more important.
You see, when there is a sentence of 7 years, getting stay also becomes quite difficult.
My lord.
Replay, please.
Item number 14.